So it's looking like we have a wide variety of participants today. Some who I know are not in the field of family law, which is great. This is going to be more geared towards you. If you are in family law, or have an interest in it and kind of been in family law for a while, this may be too basic for you. And so if you want to if you do have more experience and you want to weigh in on something, go ahead and put a question in the question box, and I can make it so that you're allowed to talk and share your insight with us. So, for example, I see Bonnie Powell is here, who's a great mediator, and some folks, I know Misty Gann knows about juvenile stuff. So if you see things that relate, feel free and let me know and we can have you chime in. So I'm going to go ahead and get started with the basics of family law. So just so you know who I am, I'm Joanna Smith. I'm the managing partner of the Georgia Family Law Project. We are a sliding scale family law focusing on providing services around divorce, child custody, and child support for folks who don't qualify for free legal services but can't afford traditional representation. And so most of our clients might have a job, have income, but really can't afford the high initial fee for a deposit, or just can't afford a high billable rate. And so we do work on a sliding scale for folks. There is a PowerPoint that's up right now, so if you can't see that, please let me know in the questions and I will try to get that worked out for you, but we're just going to go ahead and get started. And what we're going to go over today is essentially the steps in a family law case. There's a sort of a general process for all cases, and then we'll go into some specific kinds of cases and what might be a little bit different for each of those things. And like I said, just go ahead and chime in with questions anytime that you might have them, and I'll try to answer as we go, okay? So there's basic steps that apply across any kind of case for family case, and it's pretty much the same for all civil cases. So if you are more familiar with other different kinds of family cases or other different kinds of civil cases, it's going to look pretty similar. So it goes through, you file the case, you do your service, getting the documents to the other side, answer discovery. In some counties, that's going to look a little bit different for family cases, mediation, status conferences, final hearings, and final orders and decrees. So I'm going to just walk you through each of those and how they might look a little bit different for family cases. So the first thing that you're going to figure out for filing is what kind of case you have. So it's going to look a little different for a divorce versus custody versus a contempt. What county should you file it in, how much it will cost to file it, and what exactly you need to file. So what kind of case you have for divorce, sometimes the cases are treated a little bit differently if it's a contested or uncontested divorce case. And so contested is if the parties haven't agreed on everything. Uncontested is if they've agreed on everything. And generally, they will be filing a settlement agreement along with the initial petition for divorce or something like that. The documents are also very different for when they're children versus no children. For an uncontested divorce with children, you're going to need to have the child support worksheet, the parenting plan, all of that stuff all at once. And so that will be very different than if there's no children involved, in which case it will just be a settlement agreement on property and you don't have to do all of those other things. So it will look very different if there are children involved. Legitimation. So in Georgia, we have this weird situation where we can know if that the father is the biological father, but he may not have any rights and may actually be paying child support, but still have no legal rights to a child until he legitimates. And there's actually for a while there was administrative legitimation, but they don't have that anymore. So even if a dad is on the birth certificate, even if everybody knows that he is the biological father, he will still have to go through the legal process of legitimation. So you may be filing a legitimation petition. Are there any questions about that? Feel free to chime in on the Q&A if you do have questions about what any of these different kinds of cases are. You can file for child support either through child support services or through the Superior Court. So you may actually be filing a child support case in Superior Court, and that would not be that would be with the other parent as the party, so between two parents, rather than child support services being one party and on behalf of the child. So it's a little bit different when it's in Superior Court. Paternity is filed by the mother to establish that a father is the paternal father. You would file a paternity action along with a child support action if the father hadn't been ordered to be the biological father. Contempt is saying that somebody didn't do something they were ordered to do, and so that could be a follow-up to a divorce or child custody or any other kind of case like that. And then a modification is just that, modifying a previous order. So when you do go to file something, you have to figure out what county to file in. Generally, in most cases, you're going to file where the defendant lives. There's some special rules for divorce. If a defendant's spouse moved away from where the county where the parties lived as spouses, you can file in the plaintiff's home county up to 6 months from the time that they stopped living together as spouses. After 6 months, you have to file in the county where the defendant lives now. If the defendant used to live here in Georgia but now lives in another state, the defendant may be able to file in Georgia under certain circumstances, but you'll want to look up the statute. Not on this slide, but it's also important to remember, is that for custody cases, the jurisdiction is governed by the Uniform Child Custody Jurisdiction Enforcement Act, known as the UCCJEA. And so if you have a custody case where the parties that may have lived in a different state or the kid may have lived in a different state, you have to know what state to file in, and the rules around that get pretty complicated. So if you have a case like that and you're trying to figure out where to file it, feel free to reach out and I can walk you through the UCCJEA. But just generally, you're going to file in the state where the child has lived for the last 6 months. And that just prevents parents from taking your child out of state and then trying to file a case somewhere where it would be difficult to pursue the case. So just keep that in mind. There is a civil filing fee. It's around $211 for most counties. They bump it up a little bit each year, so it can differ. It may be $216 now. Most counties require, if it's a party filing it, they're going to require cash money order. If you are an attorney, you can usually use a check. Most of the counties are now taking debit cards, so that's awesome. Service by the sheriff is $50 and sometimes needs to be paid separately. If you are doing it through Peach Court, they have all of the documents right there on Peach Court and let you do the service right through that. Sometimes Odyssey doesn't let you do the sheriff's service through Odyssey. If any of you have had luck with that, please raise your hand and tell us about it, because I still haven't quite figured out through Odyssey how to get the sheriff's service going through there. And then folks who are indigent, I see Megan Polst and a couple of other folks on here from Georgia Legal Services. They may be able to file a poverty affidavit to waive their fees. If you're coming from an organization like Legal Aid or Georgia Legal Services, they have an automatic standing order that lets you automatically have a poverty affidavit. If you don't have that, it gets really super annoying. You actually have to go and provide documentation of your income and bills and expenses. And so it's a bit of a process that the clients have trouble with sometimes, but it can be really beneficial to have because it allows them to waive the fees for mediation in some counties. you know, all sorts of different things where there might be fees, okay? So then you ask yourself, what do you file? The summons, petition, you're gonna file your fees or your waiver of fees. Standing orders, most counties have standing orders, which is gonna be an order that gets put in place that applies to all family law cases. And so it's generally, they say that you can't take the kids out of the state except for routine visits. You can't, you know, get rid of properties that would be subject to division of marital property. So they can't go just sell the car unless both parties agree to it. Sometimes there's a standing order for ADR, alternative dispute resolution. Some counties have standing orders that say that all cases have to be mediated before they can go to a hearing. Some counties, that's before any hearing at all. So if you're, for example, in Fayette County, requires mediation before any even temporary hearing. And so it's, that's important to know if you're going to do that. And then some cases will require additional items. Like I said, if you're filing an uncontested divorce, you have to file all the settlement and parenting plan along with that, okay? The next step is going to be service. Service is formally notifying the other party. There has to be proper service. Oh, so I just got a question on the previous slide about you're required to file a copy of the standing orders with the pleadings. She's confused about that. You do, so in Peach Court, well, no, actually, so you are supposed to file them along with the pleadings because then they get served to the other party. And so it's good to have them just on a record in there, especially if you have a pro se person with you. And so generally what you have to do is, some counties, they already have the heading in there. In other counties, you have to actually put the different parties' names in the style, even though it's already signed. So either file them into the case, or at least just make sure you're serving the standing order on the other party, if that makes sense. Okay, so, okay, going on to service. You have to have proper service. I get questions a lot about acknowledgement of service. So personal service is when a sheriff or a private process server actually gives the documents to the other side, and then they have to file a notice that the person's been served. It's called a return of service. When you have the sheriff do it, they oftentimes will go ahead and file that in for you. It's automatic. If you have a private process server, most of them won't file that return of service in for you. They will send you the return of service that they've notarized, and then you have to file that in. You have to file that in immediately, or there's no proof that they've been served. And you're supposed to do it, I believe it's 5 days from when they were served. Otherwise, that clock doesn't start ticking for them until it gets actually entered in there. So it's important to enter that return of service. So I got a question from somebody about how tricky is it to perform service in a country like the UK. I am not your go-to person for international service. So if there's anybody who wants to raise their hand and tell us about international service, I bet we would love to know about that. But generally, when you're performing service outside the state of Georgia, then you have to, the statute says essentially that you have to follow the rules of service in the place where you're doing it. And then I believe that for international stuff, there may be service in the Hague agreements. So Pete Wozniak, thanks so much for that question. I'm sorry I don't have a good answer for you on that one, but I'll get you connected to somebody if anybody raises their hand about that particular answer. So acknowledgement of service is when you ask somebody to acknowledge service. You can do this if you're trying to keep a case more polite and don't want to send a sheriff to their door, or if you know there's imposing attorney on the other side and you wanted to keep things calm, or if you're doing an uncontested divorce, then you're going to have somebody just sign an acknowledgement of service. If you send the documents with an acknowledgement of service to someone, they have up to 45 days to do it. But it can be, you can give them a deadline and then go ahead and serve them anyway. If you give them the opportunity to serve them or to acknowledge service and they don't take that opportunity, and then, the period of time passes and then you have to have them served, then you can ask the court to award you the cost of getting them served. I very rarely see people ask for that and successfully get that, but it is there if you want that $50 or $75 or more dollars for a private process server. The publication requires an affidavit that you don't know where the other party is, and a court order allowing service by publication. Service by publication is one of those things that courts don't like you to do because they just, the publication is in the local legal organ of the county. And most counties, I could not tell you what the legal organ is. You have to look it up. For Fulton, it's the Daily Report, and that's the one that everybody knows, but other counties are different. And so it's not a great way to serve somebody because who ever reads the legal organ? And so judges really want to see that you've made an effort to serve someone or to at least search for them. So that's doing a background check to see if on Lexis, people search to try to find what somebody's address might be. You want to have your client get on Facebook and try to find friends that they have in common. And then you actually have to do an attorney's affidavit saying that you tried everything, or your client has to do an affidavit saying they've tried everything and you can't find them. And so you want to be able to serve by publication. If you're working with pro se people, make sure you explain the service process to them, because a lot of times they think they can just email somebody the documents or mail it to them, text them. They actually have to make sure they get it served properly. Okay, so discovery. Oh, sorry, did I skip? Okay, I did skip. So the other party's response is the answer. The defendant has 30 days from the date of service to respond by filing an answer. Uncontested is if a party agrees to absolutely everything. A case is not uncontested just because a defendant doesn't file an answer. And in other civil cases, if a party doesn't file an answer, then it's a default and the person who filed the petition basically can get what they want. That doesn't really happen in family cases. It's a little bit more wishy-washy. In family cases, as long as a person's participating in the case and hasn't just disappeared, a judge is probably not going to grant a default type thing. They're not going to just grant somebody everything they want. So there is no such thing as a default custody case, for example. Yeah. So if there's questions about that, let me know. But generally, file an answer. I know in other civil cases, if you go through and you admit or deny everything, if you don't deny something, then it's deemed admitted. Technically, that's true. And so if you see, if you get a case after an answer has been filed, go ahead and do an amended answer if you need to. And another thing to remember is that pleadings are required to be verified. So your answer has to have a verification. Your petition has to have a verification with it. And that's a notarized signature from your client. Okay, so discovery. I mentioned earlier that some counties have mandatory discovery. So Fulton County, for example, has, in any family case, has discovery interrogatories and notice to produce, request for production of documents that are automatic in a case. You need to check the county and see if they have those. It's only Fulton, I think, has those. If anybody else knows other counties, let me know. And for Fulton, those are all financial discoveries. So if you have just a child support case or something like that, then, or a divorce that's pretty basic, those Fulton mandatory discovery may cover everything that you need. it's good to go ahead and serve those on the other side, even though the standing order technically says that they need to be responded to in 30 days. A pro se person or a person who doesn't normally practice in Fulton might not realize those are there. So go ahead and serve those on the other side anyway. And then go ahead and make sure you are responding to those as necessary. Discovery requests are going to be your basic interrogatories, requests for production, notice to produce, and requests to admit. I had a question about mandatory discovery. It's asking if it's found in the court rules or the standing order. I believe that in Fulton, the rules are in the standing order, but Fulton also has separate family law division rules. And so if it's not in the standing order, it's in the rules. It's also in a lot of the notices. I believe the 30-day status conference notice has it in there that you're required to do the discovery before the 30-day. Insider information is that nobody actually does them by the 30-day. I think we all try to, but it doesn't always happen. And generally the judges just tell you to do it. Make sure you get it done. So that's kind of the answer to that. Everyone in cases are required to produce a domestic relations financial affidavit. That is in the Superior Court rules and child support worksheet. That's in the Superior Court rules, not in particular county standing order or rules. And those are required to be submitted 5 days prior to any hearing. And best practices is to not file the domestic relations financial affidavit into the docket because it has a lot of private information on there. But you can file a Rule 24.2 certificate that just says, I certify that I turned that DERFA, that financial affidavit, over to the other side. There's not a lot of consequences if you don't, but it's best practices to do that. And also you could get your hearing continued if you didn't turn it over in time and the other party objects to that. And so go ahead and get your financial affidavit filed in time. Discovery responses are due 30 days after service of requests. Your discovery period is 6 months long, starting from the date that an answer was due or when it was actually turned in, if that was less than that. So does that make sense? Questions on that? Okay. And then obviously, you can do things like depositions and other kinds of discovery. I want to actually, something to point out is that a notice to produce, while it acts like a discovery process, is actually under a different section in the Civil Practice Act. And so while discovery requests can be served by mail, they don't have to be personally served. A notice to produce is more like a subpoena for documents. And so it actually has different service requirements. It has to either be hand delivered or served by statutory overnight service. So you're not going to be able to just serve a notice to produce by email, and you may have a motion to quash if you try to do it that way. So remember that. For family cases, almost all counties require people to go to the Families and Transitions seminar when children are involved. If a case has happened, if this is a modification and a case happened not too long ago, they might not require it. But go ahead and have that on your client's radar to do. Most counties will accept the online one, and I put the link in there for you. And some judges will even say that if it's not completed prior to the final order, that one party won't be able to exercise their parenting time until they do it. Cobb County has a separate, pretty good one if you've ever gone to that. If you want to be a mediator or guardian ad litem in Cobb County, you have to go and attend that seminar. So it's worth checking out. So in Cobb, make sure they're doing the Cobb specific one or getting a waiver for it. But if people are just sitting around at home this week or so, it's a good time for them to do that online parenting seminar. Most counties are now requiring mediation or ADR, alternative dispute resolution, in all family cases. It's when a mediator helps the parties find a mutually acceptable resolution. The mediator is a third-party neutral. I act as a mediator sometimes, and they can't make decisions for people. They can't tell them what to do. They can't require them to come to a decision, but they will allow people to come up with their own plans rather than having a judge just decide things for them. So it's a great opportunity, especially if the parties are on, you know, weird work schedules or have sort of interesting lifestyles. It's, you know, you may not want to bring all that stuff up at court and a judge may not listen to it. So it's a good thing, good process to take people through. Oh, so somebody just asked a question about the Families and Transition Seminar, about not all counties approve online divorcing parenting seminars, and that's absolutely true. You do need to clarify with the judge's clerk or court clerk if the online one will be okay. I haven't had too many problems with slipping that in there, unless the other party makes a big deal about it. So yeah, you want to check with the judge's clerk or the superior court clerk to see if the online class is viable. So that's a good point. Thanks, Megan. So back to mediation. I've mentioned this before. Mediation is generally mandatory. It's in most counties now. For contested cases, except for contempt actions. A lot of counties will require it for contempt actions too, if it's just a contempt on money. So watch out for that. And usually they'll require it before you get to have a hearing. So get it taken care of early. One point about this, though, is that sometimes in those counties where they require mediation early, you may not be really ready for it, but you need to do it. You can always mediate a second time if that's necessary and agreed to by the parties. So you know, keep that in mind. And there's some other kinds of alternative dispute resolution. We may be able to have another session about that sometime, about alternative dispute resolution. But so you can arbitrate things, you can have a late case evaluation, all those kinds of things as well. There's different kinds of hearings. Family law gets a little bit wishy-washy, and different judges have different names of things. So a temporary hearing would be if, while the case is pending, the parties need a little guidance on what to do in the middle of the case. So that's maybe temporary custody of the child, temporary support, temporary alimony, visit, you know, who stays in the marital residence. You can have a hearing on any or all of those issues. Sometimes a judge will set a status conference or they'll call them all kinds of different things, where basically they're requiring you to show up at court and just give a check-in. And so that might not be a real hearing, but it may be an opportunity for you to check in with the court. A motions hearing is similar. It may be that you need to hear evidence or legal argument about a preliminary request. So that might be about discovery. It might be about, you know, a change in custody or financial things. So, if you file a motion, you want to get a hearing on that as soon as you can. Something to remember is that different counties handle how to get a hearing different ways. And so some you call the calendar clerk at the clerk's office, some you call the judge's chambers, some will will serve the other side for you. Some you have to, if you request it, have to serve the other side. So make sure you ask a lot of questions about how do I get a hearing, and did you guys serve this, or do I need to serve it? And then for motions, remember that if you file a motion, they don't automatically send those to the judge's chambers. So if you want a hearing on your motion, you need to go ahead and actually get a hearing date to hear that motion. Otherwise, it will just sit there forever. Same with a final hearing. The final hearing is the last hearing that the judge is going to have. It's the final. Sometimes there'll be a trial. Sometimes it's just going to be a quick evidentiary hearing. You want to make sure that when you're scheduling that the judge's office knows that it's for a final. They want to know how long it's going to be. If you're going to need it taken down by a court reporter, you need to have all of those things arranged in advance and make sure that the court is aware that it's going to take more than just a few minutes if you're going to have a full trial. You may want to get it what's called specially set, which means you get a specific time for your case rather than having it just go on a big long calendar. Okay. Let me know if there's questions. I know I'm just going through this quickly. A judge can take evidence for the final order at a status conference or at a temporary hearing and can enter the final judgment decree at that time, but sometimes you'll need that full hearing, which would be a full trial. And then sometimes you can do a judgment on the pleadings where the judge doesn't have to have you in for a hearing, especially for an uncontested divorce. You can just ask a judge to say, to enter an order based on all of the pleadings. So that would be a motion for judgment on the pleadings. Okay. For hearings, for a big final trial, a judge may require a pretrial order, and that lays out what documents are going to be admitted, how long it's going to take, what the issues are, and gives a judge a sense of what the issues are going to be during that. And so be aware that you may need to submit that in advance, sometimes as much as 2 weeks in advance. You got to prep for your trial far in advance. I got a question, do the rules of evidence apply at all family law hearings? The answer is yes. But the answer is also, because these are bench trials, a lot of times the judges will be a little bit loosey-goosey with the rules and say, I can, I'll admit that for what it's worth. And so it can get a little frustrating sometimes. But yeah, know your rules of evidence. If you, can object to things to keep them out, generally that's great. When you have pro se folks on the other side, unrepresented people on the other side, then it gets a little iffy. But yes, that technically the rules of evidence do apply at all family law hearings for what that's worth. And if there's any practicing attorneys on here who want to talk about the frustration of doing family law, trying to get the rules of evidence and the law to apply. I had another question about evidence, about when you are allowed to proffer evidence as an officer of the court. Thinking of child hearsay specifically. So you proffer evidence as an officer of the court when, for attorney's fees is one of the times that I can think of that. For child hearsay, you can't offer child hearsay just as an officer of the court. There's actually a separate section on that about, you can offer. So generally, you can't present evidence as an attorney because you are not you're not a person in the case. As soon as you become a witness, then you stop becoming the attorney. So if you have more specific questions about that, I'm happy to answer. Okay, so, and then just also Misty Gann sent a message to all of the panelists about the rules of evidence ignored in emergency protective cases and dependency cases. So that might be true. So, there may be different rules in juvenile court for certain kinds of cases. Generally, they're supposed to apply. Okay. So in the final order will be a decree, will be a final order, sometimes called a decree in a divorce. if the parties are asking for a name change, or it's an adoption, or they're trying to do a transfer of property or accounts, they're going to need a certified copy of the final order, which has that that stamp. It's usually a red stamp on it, and the textured seal from the clerk, and you'll need that that final sealed record in order to get any official documents changed. So you may want to tell your client that they're going to need to pay for a couple of those. Okay, so I'm going to go into a few specific kinds of cases now. If there's any questions before we go on, please let me know. I know I'm whipping through things pretty quickly, but want to respect everybody's time. So we're going to go into divorce specifically. So the divorce permanently ends a marriage, okay? As I mentioned, it can be contested or uncontested, and it determines how all of the property is going to be divided, both real property like a house or personal property, how all that's going to be divided, where the children are going to live, what they're going to do, other issues including child support, visitation, alimony, okay? Either party can file for a divorce, doesn't matter, and you can't object to a divorce and not have it happen. It's going to go forward regardless. And there's 13 grounds for divorce, and it looks like it got cut off a little bit here, but the 12 of those grounds for divorce require proof of fault. And so you may have heard, adultery, cruel treatment, all of that. Those require proof that somebody actually did those things. The 13th ground is marriage is irretrievably broken with no hope of reconciliation. It's Georgia's version of a no-fault divorce. It doesn't require proof. And so you'll see a lot of times people will do other grounds of divorce, and then they will also add marriage is irretrievably broken, so that if you end up not having a hearing, then that's fine. You don't have to prove that. It will still go forward. Okay, and so you're going to file that petition for divorce when you go to file it. Remember, when you file that petition for divorce, you can't get it if you don't ask for it. Okay, so even if you think you may settle where there's not going to be alimony or something like that later, go ahead and ask for it in your petition. Ask for those attorney's fees. Ask for everything, or you can't get it. If there's minor children, you have to you include those 5 required UCC JEA requirements. That includes where the children lived in the last 5 years, where they're living now, if there's any other cases, all of that information needs to be included. And then the person filing for divorce has to sign a verification. There's going to be a domestic relations intake form that the clerk files, and then you're technically, even though it sounds silly, you have to file the report of divorce form along with the divorce. It's required at the time of filing, and your filing will get kicked back if you don't have that filed in there. Okay. For divorces with children, you're technically supposed to file a proposed parenting plan, proposed child support worksheet, along with the initial filings. Very few people actually do. But for the final documents, you will have to have your parenting plan that will be signed by a judge, your child support worksheet, and your child support addendum. Some people will include all the child support addendum information in their settlement agreement, but technically you are required to have a child support addendum, and a lot of judges will require a separate addendum. Now all the child support worksheets are online, so I included the website for child support services. Play around with it, because it's easy to do once you get a hang of it, but it's worth doing, and there's a good tutorial on that website there. Okay. 2 ways to have a divorce granted. If all the parties agree on all of the issues, you're going to have settlement agreement. You can file a motion for judgment on the pleadings, have all the forms, and the judge will just sign off on it. Some judges require, when there's cases involved, they still make you come in to go over the parenting plan. Some will let you do it with a motion for judgment on the pleadings. Okay. If if the parties don't agree on all the issues, even after mediation, because if you agree at mediation, then you can sometimes do it without judgment on the pleadings. Then you'll still have to have a hearing in court, and you'll still have to file all the forms, the child support worksheet, child support addendum, all of that. Okay. So the next kind of case is legitimation. As I talked about, legitimation is if a man fathers a child out of wedlock. He is not the legal father unless they sign, both the father and the mother signed an acknowledgement of legitimation between January 5th and July 2015. During that time, there was administrative legitimation. And so if you have a child that was born during that time and dad was at the hospital with mom, it may be possible that there was a legitimation at that time. Oh, I had a question in here from the previous slide about whether a motion for judgment on the pleadings is effectively the same as a consent to trial in 31 days. No. So if you are filing an uncontested divorce, then you will have a party, you may have the respondent file a request for, or a consent to trial within 31 days. That does not, that's not the same as a motion for judgment on the pleadings. That just says that you can go ahead and do the motion for judgment on the pleadings. You still may need to file a motion for judgment on the pleadings or get a final hearing date. So it's just basically releasing it for final trial, if that makes sense. It doesn't waive the need for that motion for judgment on the pleadings. Okay, so going on to legitimation again. So if it's, yeah, so there may have been an administrative legitimation during that particular time. If a father marries the mother of a child, then the child automatically becomes legitimated, which is crazy, but it's that public policy thing of the government wanting people to get married and a child having two parents. And then if a father files a legitimation in Superior Court, then that would legitimate the child. As a side thing, we do not know how this law interacts with the same-sex marriage laws and kind of that evolving thing. We are right now treating children who are born during a marriage as if they're legitimated, even if it's for example, two women, if the child's born into that marriage. The law isn't clear and it's not great. And so while we're treating them as legitimated, it's kind of still wishy-washy there. As I mentioned earlier, a biological father still has to pay child support even if he doesn't legitimate the child. It's a weird Georgia quirk, and only fathers can file petitions for legitimation. Okay. Next kind of case is child support. So in Georgia, it's the law, all parents have an obligation to support their children, even if there's not an order in place. And parties can file for child support either through the Superior Court or through child support services. So you don't have to do both. If you have one case and then you start another, depending on the county that you're in, you can get it moved one way or the other or dismissed, but some counties are wonky. So you can have a divorce going on and still have a child support case going on. And it can be a little weird. The court can impute income where appropriate. So you always try to do discovery where necessary to, get the information necessary to file a child support order. If one party's not working, but they could be, or if one party is not working to their potential, then you can ask the court to say, okay, this person should be working more, and so impute income for them, okay? But generally, you're going to use the child support worksheet and just put both parties' income in and get a number. They also consider things like the insurance, the health insurance for the child, if there's any child care expenses, all of those things go into the child support worksheet. So reach out if you need help with child support worksheets. I'm happy to walk you through them. Okay. The next kind of case is a modification. So a final order is final unless it's not, but if you want to change a judge's order, you have to ask the court to modify its final order for child support, alimony, custody, or visitation. Okay, you cannot modify a property settlement. Okay, and to get a modification, you have to show that there's been a substantial change in circumstances. So for child support, that is essentially a 25% decrease in income is considered a substantial change. Less than that is not considered substantial. So you got to kind of keep that in mind. And you can only modify once every 2 years or in extreme circumstances. So when people say, so I got a modification of child support last year, can I change it this year? The answer is no, unless there was a big change. So it's a little bit wishy-washy there. But if there hasn't been a huge change and you ask for a modification, a judge may throw it out. Okay. This is basically what I did. The modification of child support or alimony, you have to show a substantial change in financial circumstances or a substantial change in a child's needs. So if a child ends up with a disability and becomes a lot more expensive to take care of, you may be able to get an upward modification of child support even if the 2 years hasn't passed. Something like that. A modification doesn't go back in time. So if you have been accruing arrearages and are in contempt, you can file a modification today, but that doesn't stop you from still owing what you've accrued. And so if your client is not able to pay, you want to make sure you file that modification as quickly as possible because they're still going to owe any arrearages up to that point where the modification actually happens. Okay. And you also want to get a hearing as soon as possible to modify that order so that arrearages don't continue to accrue. So a contempt is when a party hasn't done what they're supposed to, and according to the judge's order, and you're asking the court to say, hey, you need to actually enforce that ruling. You have to be able to prove in court that the other party is in contempt. And so contempt has two things. You have to show that the party didn't do what they were supposed to do, and then also that they willfully didn't do it. So, and then if you are defending against a contempt, you can either show I did do what I was supposed to do, or I didn't do it, but it was because I really couldn't do it. Those are your only defenses to contempt. Okay. And you cannot file for contempt if you have unclean hands. So that means you can't say, oh, she didn't, pay the fees that she was supposed to pay if you weren't paying the fees that you were supposed to pay. The judge isn't gonna like that. You also can't file for a modification or contempt if you are withholding visitation. So keep that in mind too. I have a question here about jurisdiction. If the parties move to another county or state, will jurisdiction remain with the court that issued the final order? For a contempt action, it's going to stay in the court where that actually issued the order. If it's in, so you can always do a contempt in that county. If you're doing a modification, you're going to file the modification in the county where the defendant lives. And so sometimes you'll end up with a weird, if both parties are filing a modification of custody, for example, you'll file one in the defendant's county and then the other petition will be in a different county, and then you'll have to get one transferred so that you can combine them. So it's very strange. If you've moved out of state and both the parties are out of state, you can domesticate a foreign judgment, basically allowing the jurisdiction to be moved to the state where both parties are. So I had one recently where the parties had both lived in New York, and then they both separately moved to Georgia. We're not going to have a modification or contempt in New York because nobody lives there anymore. And so we had it domesticated here in Georgia, and then can actually have the hearing about it here in Georgia. So kind of a nuanced question. So what, so that's the content that I have for you guys today. This is my number at the bottom here. I'm happy to take your questions. I think I answered everybody's questions here, but if anybody has other questions, I'm happy to answer them. There is, you know, family law is one of those things that is nuanced and all over the place, and can feel like a whole nother world if you're not dealing with it every day. So I'm always happy to answer your questions. Anything else that you want to do, that you want me to do for the group now? Or anybody have anything they want to weigh in on? I'm happy to allow you to talk, and you can share with the group your perspective. Okay, so I have a question here about the process for filing a legal separation. So that is possible here in Georgia. It's a little bit different than some places. You're essentially filing a petition. It's very similar to a petition for divorce, but you're filing a petition for a legal separation. And then you have a full settlement agreement just like in a divorce. And so you want to make sure that your clients know that if they're going to do a legal separation, that they then will have to, if they ever want to get divorced, do a whole nother process for divorce, a whole new petition, a whole new thing. So just, you know, keep that in mind. Any other questions today? I thank you all so much for being here. I know it's a crazy time in the world. Lawyers for Equal Justice and my law firm will be trying to have some more stuff going forward. So if you have things that you want to learn about that we can help you with, either with family law or another area of the law or practice management, let me know. If you would like I've recorded this, if you want the presentation or the recording of the presentation, email me and I'll send it to you. And let's see, I have somebody here. Yeah, and so I'm here for questions if you need me, but have a great day. Stay safe out there. I appreciate you guys.